A warm welcome to the viewers of Legal Talks. Today, Advocate Dr. M.Sathya Kumar is with us. Welcome, sir.
Good evening, Ram.
Whether a bail should be granted in case of a serious economic offence?
If you see, Ram, there are two types of bail. One is the anticipatory bail and the bail which is granted after the person is taken into custody. Recently, Gujarat High Court has come out with the judgment wherein they have clearly said anticipatory bail should not be granted. The wording used is should not be granted in case of serious economic offences. Two important words to be noted here is should not be granted and in case of serious economic offences. So this was an highlight on the observation of the Gujarat High Court in the case of Hitendra Chandrakant Shah versus State of Gujarat, criminal miscellaneous application number 16639 of 2023, dated December 6, 2023. The question here is, the question that was raised in the petition, wherein relying upon the judgment, in the case of Nimmakada Prasad versus Central Bureau of Investigation, criminal appeal number 728 of 2013, dated May 9, 2013, it is noted that in cases pertaining to economic offences should be dealt differently, as it can lead to huge loss to the economy of state. Also, the court relied upon in judgment in the case of Chidambaram versus Directorate of Enforcement, criminal appeal number 1340 of 2019, dated September 6, 2019. It was stated in the judgment, in case of economic offence having an impact on the society, the court should be slow in exercising discretion for granting anticipatory bail under section 438 of the Criminal Procedure Code 1973. If you see, Ram, especially with respect to economic offences, and if you go through the observations of the Supreme Court and the High Court with respect to economic offences, generally it is very, very difficult to get a bail for economic offences because of a single reason: the digital transaction and the money trail would be destroyed if the accused is left free. Accordingly, even if the accused approaches the court for anticipatory bail, in most of the cases of economic offences, anticipatory bail is denied. But here is a judgment of Hitendra Chandrakant Shah versus State of Gujarat, wherein it was clearly said anticipatory bail should not be granted in case of serious economic offences. And accordingly, in this judgment of the Gujarat High Court, it is opined that prima facie a case of serious economic offence has been made out against the petitioner. The petitioner has approached the court for the anticipatory bail, and there is a serious economic offence that has been made out against the petitioner. Accordingly, having a wide impact on society, in fact, economic offence is an offence. It's an offence against the society. Accordingly, no case is made out for granting the relief of anticipatory bail to the petitioner accused, held that the petition is dismissed. So this anticipatory bail petition that was made as a submission before Gujarat High Court has been dismissed for a single reason: anticipatory bail should not be granted in case of serious economic offences. The Gujarat High Court has relied upon multiple Supreme Court judgment for arriving at this judgment, Ram. So the lesson to be learnt in case of economic offences, in case of GST or Prevention of Money Laundering Act or income tax prosecution cases, in all these cases coming under the economic offences, which is a huge loss to the economy, anticipatory bail should not be granted is the observation by many of the high courts and even by Supreme Court and even Sessions Court judgments, which we can see in the recent times. Accordingly, bail is a difficult thing in case of economic offences is the understanding we should have, Ram.
And what are the factors which would determine whether an economic offence is serious or not?
The factors generally that determine economic offence is serious or not is basically the quantum of money involved in that respective offence. If you see the quantum of money and number of people involved and complexity of transaction, The very important observation that you need to understand, the complexity of transaction. Take for example GST frauds that are happening now. Most of the GST frauds are happening because there is a bogus invoice wherein they print and then fake input tax credit is taken, and then they incur loss to the government exchequer. Accordingly, it's a big impact on the society. Think about a situation where this GST should have been paid to the government and that money should have been allocated for socio-economic development. That means if that portion of GST is defrauded, that means it is not going to the socio-economic development of the country, which is a crime against society. So this is one of the serious fraud which we can see in the recent times. The GST input tax credit, fraudulent credit, has been a trend that's been happening around the country. So the department is actually vigilant about it. Department is actually coming over and then investigating these matters. That is one type of economic offence. The second economic offence is the economic offence with respect to Prevention of Money Laundering Act 2002, where there is a predicate offence, and when there is a predicate offence and there is a proceeds of crime, as per Prevention of Money Laundering Act, wherein people are involved directly or indirectly. In those situations, it also comes under the economic offences. That is the reason you see when somebody is arrested by Enforcement Directorate, it is very difficult for them to get a bail. Definitely, anticipatory bail will not be provided. Even bails which are applied under the CRPC
after the arrest
is very difficult for them to obtain, because of a single reason, it's an economic offence. And even company law offences which are coming under the category of section 447, that is a definition of fraud, where somebody has made wrongful gain on wrongful loss, and it is categorized as fraud because there is a malafide intention. And accordingly, if it is coming under section 447, now we have section 212 and 217, wherein serious fraud investigation officer starts the investigation. Even in the case of serious fraud investigation officer, and when person is arrested, any person is arrested, it is very difficult to get a bail, because even serious fraud investigation SFIO proceedings come under the serious economic offence, because they use company as a model for various fraudulent activity or scams which affect the people directly. So accordingly, in these circumstances, courts have been very clear that anticipatory bail should not be granted. The jurisprudence of the bail with respect to economic offences became very strong from 2016 onwards in Jagan Mohan Reddy versus CBI, wherein the jurisprudence became very strong, wherein they went on to say, in case of other offences, bail is a norm, jail is an exception. In case of economic offences, jail is a norm, bail is an exception. I am sure that this gives a clarity for the legal enthusiast and law students, wherein how bail jurisprudence has evolved with respect to economic offences, Ram.
Thank you for a valuable input, sir.
Thank you, Ram.